The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Experts Show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good afternoon. God, it's dark out. I guess it's not afternoon anymore. Welcome to the Ask the Expert Show. We're on every Monday and Thursday night from 6 to 7. And I'm going to tell you something. We got a great show tonight. If you would like to watch tonight's show, go to, it's Ask the Experts. This is on our Facebook. Go to Ask the Experts with host Steve-O, and you can actually watch tonight's show. So let me introduce you. This is like my favorite show. The phones ring off the wall. They've been doing it for the last 2 years. Let me introduce you to our expert tonight. Oh, is he an expert? Let me introduce you to Robert Kaye. He's one of the senior partners at Kaye, Rembaum. They do community association law. So if you live in an if you live in an HMO or wait, what am I doing? An HOA or a condo association, and especially if you're a board member, we really want to take your calls tonight. You can call here at 888-565-1470. It's 888-565-1470. Maybe I shouldn't give out the number with all the calls we get, but let's welcome Robert Kaye.
Hey,
See, I'm on a lot of medication, Robert.
What's that?
You should feel sorry for me.
I do feel sorry for you, Steve.
How are you doing?
Hello, everybody.
It's been kind of crazy out there. At least it'll be sane in here.
We hope so.
Yes. So, you know what? I was shocked. Last month, I looked at the numbers for the show, and I was shocked how much they shot up. So, talk about traction. So, we have all these new people. So, tell everybody about your firm.
Okay, thank you, Steve. And hello, everybody. Kaye Rembaum is a full-service law firm, but we primarily specialize in the area of community association law, being condominiums, homeowner association, cooperatives. And we provide legal services for all aspects of community operations. We review documents and provide opinions as to the rights and obligations of the association, what the board can and cannot do. We deal with issues of covenant violation. We assist in collection of unpaid assessments. We assist with contract negotiation, contract disputes, and other types of litigation associations find themselves involved in. Fair housing issues, pretty much across the board, everything a community association deals with on a day-to-day basis.
Well, I got to tell you, we have the calls already starting to come in already. I got to tell you, what we do here on the show is the week of the show, we ask you to send us your emails or text. And if you have a question, this way we can kind of, in case one of Robert's cousins calls, we don't want to put them on the air.
Why not?
Yeah, that's true. So, and tonight we'll talk about the different courses you have coming up, classes you have coming up. And I'm telling you, if you're thinking about becoming a board member, this is the greatest show to watch or listen to. We are on 5 stations. We are on 95.3, 103.9 FM, 96.9 FM, 1470, the mother station, and you can also reach us on iHeart under WWNN. So let's get started. Are you ready?
Well, don't forget, you can also see it at kbrlegal.com.
That's right. So let's go to our first call. I believe it's Jay. Jay, are you still there?
Yes, I am. Good evening, everybody.
Hey, how are you doing
Hello, Jay.
tonight?
I'm doing fine, thank you. My question has to do with the board of directors is making some rather significant changes to the landscaping in our community, landscaping that's been around for 20 years. And I'm just wondering if the board is allowed to make those changes on their own, or if there should be a landscaping committee that is involved in making the decisions.
When you're dealing with the maintenance of the common areas, did you say you were a condominium or an HOA?
Well, we're an HOA.
Okay. Uh, Most of that information is going to be specified in your governing documents. For the most part, the maintenance decisions for the common areas will fall to the board of directors. The board of directors may choose to appoint landscape committees. Some governing documents will provide a specific requirement of having a landscape committee and procedures for how that landscape committee is staffed. So you'd have to look to your documents to see if there is a specific obligation of the board to have a committee, or if it's optional, in which case the board can either have one or not.
Okay, understood. And the landscaping is never, for lack of a better phrase, grandfathered in. In other words, if they're making a significant change to privacy shrubs that have been there for 20 plus years, they can do that at their will.
If it's the common areas and the governing documents provide for the association through the board to be responsible for the maintenance, repair, and replacement, as it were, of all the landscaping, then yes, the board could do whatever the board reasonably decides to do, regardless of the age of the landscaping that's currently there.
Fair enough. Thank you very much.
All right, Jay, thanks
Jay.
for listening.
Okay, bye-bye now.
Let's go to Peter. Hi, Peter. Is Peter there? Sounds like Peter's talking to the missus.
Or Peter's listening to the show.
Yeah. Let's try one more time. Peter, are you there?
Yes. Yep, I'm here.
Oh, okay.
You're
Thanks
on
for
the air.
holding.
Oh,
Do you
thank
have a
you very much.
question for Robert?
Yeah, just a quick question. I'm in an HOA, and we had a situation where we had pretty much the same board for approximately 10 years, and a number of our policies, as far as upkeep and so forth, were just ignored. Do I understand correctly that as long as there's something in your documents that allow a new board to start to enforce rules that had not been enforced in the past?
Okay,
as
so
opposed to
if you're talking about a situation in which the board has allowed enforcement to go by the wayside and specific restrictions are not being followed, there is a procedure that the new board can undertake to basically resurrect these provisions that, in essence, have been waived by the lack of enforcement by the prior board. That procedure is called republication, and what it requires is first the board to establish at a properly noticed board meeting that it is the intent of the board to once again start enforcing these specifically identified restrictions. And that is followed up with a letter or other communication that you normally do within the community that identifies the specific issues that will begin enforcing, when the enforcement will begin again. Depending on the issue, there may be a need to have a regulation of existing violations, so anyone who registers would be grandfathered in, and they existing have to remain. You can't go back and republish and then start enforcing against the existing violations. For instance, let's say somebody made an alteration to the exterior of the home that isn't allowed, uh, painted it the wrong color, and that wasn't enforced. And
Hmm.
then the board republishes, we're going to start enforcing the color palette again. Going forward, you cannot make the wrongly painted house immediately change. When they go to repaint in the future, they would be able to. But we suggest in that instance having all the violations that are grandfathered in register with the association on a form that the board provides. And anyone who registers is grandfathered in. Anyone who doesn't register is presumed to not have been in existence when the republication became effective, in which case they would be subject to enforcement just like anyone else.
Understand. One other question, if I may.
You
Sure, go
may.
ahead.
Okay, there were so many unenforced rules that the new board has decided to kind of just baby step change them, accordingly, especially now during the COVID situation, to effectuate changes that wouldn't cost our unit owners any money, but just to say, hey, we're going to enforce this rule now, parking, for example, violation that had not been enforced in the past, and let everyone know that we are going to do so. We can baby step that, not necessarily turn around and just enforce every rule that was broken in the past.
Well, my initial answer to that question is yes. You do also need to keep in mind that there have been decisions in the past, and then this is not on any appellate court level, so it's a case by case basis. When there was a general lack of enforcement of everything in the community, that if the board were to cherry pick, there is a potential that upon enforcing, if it goes into a formal litigation situation, that the court could determine that you couldn't pick it so specifically. But I think in my general opinion is yes, you can choose to do that. There is a potential of a adverse ruling, but I think the likelihood is relatively low.
Understand. Well, thank you very much.
Thanks,
All right,
Peter.
thank you for listening.
We're
My
going to go to
pleasure.
break, and we come back. We've got George. George, don't go anywhere. We're going to go to a short break. Give everybody the phone number and the website, Robert.
Can reach us at 800-974-0680, or you can contact us at info at the initial kbrlegal.com, or just go to the website at kbrlegal.com, and you can fill out the contact form, and we'll get back to you that way.
The greatest website. And folks, I
Thank
got to
you.
tell you, this is the Cadillac of HOA and condominium association law firm. The Cadillac. They are the best in all of Florida. We're going to go to break. When we come back, we'll have George on the other side.
Kaye Rembaum is a full-service community association law firm devoted to the representation of more than 1,200 community associations throughout Florida under the direction of attorneys Robert L. Kaye, Esquire, Michael S. Bender, Esquire, and Jeffrey A. Rembaum, Esquire. Kaye Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. Kaye Rembaum assists clients in all matters of association representation, including, but not limited to, collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Kaye Rembaum also keeps clients up to date on new developments in the condo and HOA law and how they are personally affected by them. Kaye Rembaum provides prompt, effective, high-quality, cost-efficient, and understandable legal advice and services to a diverse client base. Call Kaye Rembaum today at 800-974-0680. That's 800-974-0680.
and we are back. This is the first Thursday of the month, so that means Kaye Bender Rembaum. If you have a question, we have Robert Kaye with us, and he is amazing. I mean, he actually answers questions so even a guy like me would understand. If you'd like to call here, especially if you're a board member or a management company, or you think about going on the board, but we take them all. You can call us here at 888-565-1470. That's 888-565-1470. Let's go to George. Hi,
Good
George.
afternoon. Good afternoon. This is the first time I've called in, but I would like to thank your firm because I've attended in person and most recently over the past 5 or 6 months, several of your webinar presentations. And I'd just like to thank you and your firm for all you do to try and make things clear here in Florida. A quick question on for an HOA. Our HOA was, in a sense, officially started in 1989. Well before there was a Florida Statute 720, well before there was the ability even for a condo to pool reserves. Our developer, because there was absolutely no other option for him, actually set up what are typically called component or straight line reserves. And I've tracked down, we moved here in 2012, so I've had a little bit of difficulty tracking down 32 years of stuff. But what I've been able to track down is that consistently over the past 32 years, both in our component reserves for bridges, for roads, for the clubhouse, for golf. And then about 2 months ago, they came out with an interim financial statement, and there was one account called reserves. Okay, I don't remember in the past 7 or 8 years that I've been here, and I can't find anywhere else where there was actually an official members vote to take these component or what they call straight line reserves and put them into pooled. Now, I don't want to accuse anybody of anything, but I know why they're doing it. We have a small executive, 3,500 yard par 61 golf course, and they want to pour a lot of money into that, but we don't have enough money in the golf reserves. So they're saying, well, and the excuse they use, well, if it's pooled reserves, it's easier to keep track of. But that's not the real reason. They just want to dump it all into pooled reserves so they can use it for the golf greens. Don't they have to have a members meeting and a members vote to take it from component or what's called straight line reserves to pooled reserves? Thank you.
And you said you're a condominium, correct?
No, we're HOA. An HOA, but we started in 1989 setting it up with straight line reserves because, as I said, there was no 720 in 1989. You couldn't, even if we were a condo, you couldn't pool reserves until 1992. So, the developer did the right thing. He said, there's no rules for HOAs, so I'm going to at least follow what at the time was the condo rules. So he set it up for painting, paving, and roads, or painting, roofing, and roads, or whatever. That made perfect sense. He was covering his butt.
Okay, well, here's the situation for you. As you sound like you've been a student of the statutes over the years, you know that even when Chapter 720 first came about, beginning in Chapter 617, and then when it was switched over to 720, there was no provision for reserves at all. About 10 years ago, the statute was amended to provide for the ability to have what I call the statutorily protected reserves, which means that once you have them and you can only use them for the purposes for which they are allocated unless there's a vote of the owners to do something different, and which is why in a condominium you need to have a vote of the membership to go from a straight line method to a pool reserve. But in an HOA, when the statute was created, it indicated that you could only have these protected reserves if the developer initially provided for them in the documents, which while they may have had things called reserves, it really didn't qualify prior to 2010, or the owners voted to establish these statutorily protected reserves. If the owners in your community never did that, then your reserves are in essence a contingency fund that the board can use for any bona fide purpose that the association does under its functions, regardless of what it's allocated for initially without a vote of the owners. So while they recently have shifted it from a straight line to a pool, the statute as it currently exists does not consider that to be a violation.
Thank you. You have explained it perfectly. That unfortunately was the response that I was hoping not to get, but I understand it perfectly. You've explained it perfectly. So as I said, I just wanted clarification because our board is doing things, and all I want them to do is to do it right. Just do it right. And thank you. Your explanation is, as my wife would say, perfectly spot on. So thank you again.
No, great.
And
Thank
George,
you.
the check's in the mail.
Mm-hmm.
I'm sorry?
I said the check's in the mail, George.
Oh, okay.
Thanks so much for calling.
I have a virtual check. Where do I send it?
Yeah, that's right.
info@kbrlegal.com.
I have your website on one of my favorites. So again, thank you very much.
Wow.
You guys do a great job. Thank you.
Well, keep listening, George, because we have a lot of classes coming up this particular month and webinars that you might find of interest. And if you would like, Steve, I'll go through the list.
We're going to do that right now.
My MacBook Pro and my iPhone have more KBR stuff on it than I have to fit in a lunch with my wife in between your webinars.
Okay, well, here's some more that's
Robert's
coming up.
watching.
Thank you.
Okay.
On November
Thank you
10th.
so much, George.
Take care.
Yeah.
Thanks.
November 10th,
So let's
next
talk about
Tuesday,
those classes
is a
coming
big
up.
day, Steve. November 10th is a big day. We have two of them, and they're both via Zoom. At noon on Tuesday, November 10th, we're presenting with Campbell Property Management. Jumping into the present while updating the governing documents of your association is critically important. Lisa McGill of our office will be the instructor. There's 1 credit hour for managers of continuing education credits, so that's something they might be interested in. For you, Steve, Tuesday night at 6:30, we kick off the Ask the Attorneys by Zoom this time, in conjunction with the City of Tamarack. We'll debut our 13th season of Ask the Attorney. Michael Bender and I will be participating via Zoom at 6:30 on Tuesday, November the 10th. And this is one where the participants are the ones who establish what we talk about, much like this show. You can ask your questions, have them ready. We'll have an individual that's collecting them through the Zoom program, and we'll be addressing them. This is our first attempt this way, so hopefully this will work out to everyone's benefit, and then we'll continue on during the season instead of going remotely as we would have hoped to do, but we'll at least have the Zoom method. So that would be next Tuesday on November the 12th. What's that?
How do they do the Zoom method? They just go to your website?
Yeah, all of the information for registering is at kbrlegal.com/event-calendar, or go to the website kbrlegal.com and click on events and calendar, and you'll find how to register at that point. On November the 12th, Thursday at noon, for a 1-hour Zoom, again in conjunction with Campbell Property Management, Andrew Black will be instructing covenant enforcement for HOAs and condominiums. Again, there's going to be 1 continuing education credit hour for managers. That's next Thursday, November 12th at noon. On November the 18th at 11 a.m. to noon, another hour for covenant enforcement, again for HOAs and condominiums with Allison Hertz as a again have the continuing education. I'm using my cell phone today, and I get text, and it knocks my phone down. On November the 19th at 1 p.m., there'll be a 2021 legislative forecast, federal and state realities and priorities, which will be Michael Bender, along with Don Bowman from the Community Associations Institute. That's a 1 hour from 1 p.m. to 2 p.m. And then on November 24th at 11 a.m. to 1 p.m., 2-hour course, the 2021 legal update. This is a new course for all the legal changes that happened in 2020. Allison Hertz and Michael Bender will be the instruction, and there are 2 continuing education credits for manager. That's November the 24th at 11 a.m. So that's what's happening in November.
Boy, that's a full month.
We have a few things to do.
Month. Wow. Let's go to break. Give everybody your phone number again and the website address.
You go to kbrlegal.com and you find the calendar of events. It's it's available, readily available. And
HBO.
There'll be links to establish your participation in any of these events and get you set up. We've had many Zoom seminars, and we will continue to do that throughout this difficult times.
Okay, we're going to go to break. When we come back, we have more with Robert Kaye. If you want to give us a call here, the phone number is 888-565-1470. That's 888-565-1470. If you have a question for Robert, give us a call here. We'll be right back.
Kaye Bender Rembaum is a full-service community association law firm devoted to the representation of more than 1,200 community associations throughout Florida under the direction of attorneys Robert L. Kaye, Esquire, Michael S. Bender, Esquire, and Jeffrey A. Rembaum, Esquire. Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. Kaye Bender Rembaum assists clients in all matters of association representation, including, but not limited to, collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Kaye Bender Rembaum also keeps clients up to date on new developments in the condo and HOA law and how they are personally affected by them. Kaye Bender Rembaum provides prompt, effective, high-quality, cost-efficient, and understandable legal advice and services to a diverse client base. Call Kaye Bender Rembaum today at 800-974-0680. That's 800-974-0680.
You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 6 p.m. Now, get ready for more Ask the Experts.
I guess we have to get that intro recut. We're on every Monday and Thursday, 6 to 7 p.m., and our new show on Tuesdays from 7 to 7:30. So you want to put that on your calendar. I got to tell you, we came to one of your Ask the Lawyers. I got to tell you, first it lasted 2 hours that day. And I know there was about 45, 50 people in there. And one of the things I noticed is people came in with questions, but then through the seminar, they were writing down new questions that they didn't think of. It was the fastest 2 hours. I'm not even in the business, and I really enjoyed what you and Michael did that day. It's really fun.
Well, thank you for that. And while those live ones in person are a town hall format, and then there's some conversations crossed between the participants, somebody in the audience may have an experience that is relevant to the question that's been posed, and that happens on a regular basis. But how that'll work out in the Zoom is something we're going to see if that's possible.
Oh, you'll pull it off. It's.
Well, we'll
Do you
certainly
like
be
the
able
new?
to take questions.
Do you like the new way of doing business?
We were talking about that earlier today, and it does have a lot of benefits on these remote type meetings. They're more efficient. Certainly, we don't have the time to go between places, and we're able to see more people during the course of the week than we otherwise might. So, there is a lot of positive. A lot of our clients are finding that their meetings are running smoother. And one of the benefits that the Zoom format provides that we understand is the ability for the host, the chairman of the meeting, to have a little more control. Some of these meetings sometimes get out of hand when people don't want to wait their turn and shout out and are disruptive. So you have the ability to mute everybody except for whoever you want to recognize, and they have their turn. So the meetings are more orderly in that aspect. So a lot of positive things have been seen. A lot of people are looking into continuing to do this when it's no longer a necessity.
Right. So, this new way of doing business. Now, you being one of the largest and most successful um, HOA community association firms, you get a lot of calls from properties that want you to do a presentation. So you do your presentation this way too, through Zoom?
Yeah, sometimes, yeah. There's been some meetings with people because a lot of people still want to see you in the flesh. We have to make sure we take all the precautions. They're taking all the precautions, but still, people are nervous. So uh, we are able. We have many just regular meetings with clients during the course of a week that are done on the Zoom platform.
Okay. Well, gosh, if I don't get to these questions, I'm going to have some people really upset with me. So let's start with Jackie from Boca Raton. I guess she is a snowbird and she wants to know if she can get a refund for the pool and clubhouse since they're closed. We had a lot of those, Robert.
Well, yeah, that's a pretty common concern. Like you have facilities that you have to pay for, but you can't use them because of the current conditions. Although things now, there may be more openings going on than there were in prior months. But unfortunately, the association continues to have expenses in operating the community. And it isn't a matter of pay as you use. It's a matter of everybody who owns has to pay their fair share of what expenses the association incurs. So unfortunately, there is no issue or option for the association to provide refunds. Now, if there are expenses the association had budgeted for that would not be incurred because of the inability to function or have certain facilities open, that could lead to not necessarily a refund, but a reduction in assessments needed in the next year. So rather than a refund, you see a reduction in your assessments on an ongoing basis. That could happen. That doesn't mean it will. Every community's got its own issues when it comes to that type of a problem. But unfortunately, there is nothing in the law that would compel the association to issue refunds under these circumstances.
Okay. This is from Michael in Fort Lauderdale. By the way, the phone number here is 888-565-1470. It's 888-565-1470. Next one is from Michael in Fort Lauderdale. They want to know, what do you think about having a meet the candidate night? so we can get to know new candidates better.
Well, I think that's always a good idea for the members to have the opportunity to meet candidates who are running for the board. There is nothing in the law that compels it unless your governing documents provide for it. Otherwise, it's just an optional thing. So then it becomes a business decision of the board as to whether or not to do it. Personally, I think that there's no downside to it, other than getting people together during a pandemic, which is always a bad idea, but it can be done on the Zoom setting, just like any other meeting. So, you know, I see nothing wrong with it.
Okay. William from Delray Beach, I guess he's in a HOA, wants to know, is there a time limit the board has to amend the amendment to the partial owners to allow them to vote?
I'm
What
not
is a partial
entirely sure I
owner?
know what he means by the question. Um, Amending an amendment, I'm not sure what he means. If there's a proposal out there that they're considering that they want to change. When you're talking about partial owners, documents usually provide for when there's multiple owners that they have to choose amongst themselves as to who has the voting capability for that unit and provide a written notification to the association, which is kept on file, who that individual is. A large percentage of community association documents do have that requirement, so you should always check to see if there are multiple owners of a property, that how that is specified. If it's not specified, then each owner could be voting for that unit, but each unit only has typically one vote. So
Right.
whoever is among the owners who votes it, you only get one shot at it. You don't get to have each partial owner casting a vote unless the documents
So a
specifically
partial,
provide for it.
partial owner is when there's multiple owners.
Well, that's what I would think it would be. Instead of a full
I've never
owner, you
heard
got
that.
people becoming a part. That makes them a partial owner. It's
Okay.
not a normal term that I see, but that's what I'm
I've never heard
surmising
that
is.
before. Okay. Here's Gary in Palm Beach. He said, we had so many people with mask questions this time. It
No,
says our board
mass
has
has been a
a
big
rule.
topic.
Yeah. It says our board has a rule you must wear a mask in the clubhouse. What about when people come to vote at the clubhouse? Do those rules still apply? We are a 55 and over community.
Well, being a 55 and older community, then clearly you've got people who are at a higher level of potential risk if they're exposed to the virus. So certainly you want to be as proactive as you can in protective measures. It is an enforceable requirement for communities to compel people to wear masks when on the common portions of the community. Enforcement is always a difficult issue, particularly when you have people that are resisting that. I'm not sure if they're referring to if their community is used by the general public as a polling place, as some of them are, or if they're
Yes,
talking about
the
just
clubhouses.
owners and community. If you're talking about outsiders, well, outsiders are still bound by the rules of your community when they come into it. I know that has been an issue statewide that generally was decided that if somebody comes without a mask, they'd still let them vote. Some places had designated areas for people without masks to be, as opposed to intermingled with everybody else. But on your private property, even under the situation of having it as a polling station, those restrictions should still be applicable. Fortunately, we're not going to be having another vote in the near future, so hopefully this is all behind us by the time that happens again.
Phone number here is 888-565-1470. We're going to go to break. Robert, give everybody the phone number where they can reach your office tomorrow morning?
You can reach us at 800-974-0680, or you can send an email to info@kbrlegal.com, or go to the website at kbrlegal.com. There's a contact you request form right on the front page. You can fill that out. We'll reach back to you right away.
Okay, we're here with Robert Kaye of Kaye Bender Rembaum. We're going to go to break. We'll be right back.
Kaye Bender Rembaum is a full-service community association law firm devoted to the representation of more than 1,200 community associations throughout Florida under the direction of attorneys Robert L. Kaye, Esquire, Michael S. Bender, Esquire, and Jeffrey A. Rembaum, Esquire. Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. Kaye Bender Rembaum assists clients in all matters of association representation, including, but not limited to, collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Kaye Bender Rembaum also keeps clients up to date on new developments in the condo and HOA law and how they are personally affected by them. Kaye Bender Rembaum provides prompt, effective, high-quality, cost-efficient, and understandable legal advice and services to a diverse client base. Call Kaye Bender Rembaum today at 800-974-0680. That's 800-974-0680.
And we are back. It's the final quarter of our show. First Thursday of each month, we have the Kaye Bender Rembaum show. And I guess by all the emails and the phone calls we get, people love the show. Let's go to our next caller, Tom. Hi, Tom.
Good evening. Good evening. I have a question. I have a CAM license and I manage a number of associations. One of the associations, the board of directors must have 5 people in it. Next time we have an election, it looks like only 2 are going to be left, so they're out of quorum, of course. I'm wondering what the cost of receivership is.
Well, if there are 2 individuals who are still on the board, they have the authority to appoint additional people if there are anybody who's willing to serve.
Yeah, that's the problem. Nobody wants to run.
If you cannot, well, they wouldn't be running at this point. They would just be appointed. If you cannot seat enough individuals to constitute a quorum of the board, one other option would be reducing the size of the board so that your quorum number is less. It might take an amendment to your documents to accomplish that, depending on what the requirements are. And the other option would be, as you've indicated, a receivership. Receivership has a procedure that you have to follow where you have to first send a notification out to the community by certified mail that if things don't change within 30 days, that you'll be filing suit in the circuit court to have a receiver appointed to operate the community. And at that point, you file the case in the circuit court. The court will appoint a receiver who takes over complete control of the association. The receiver typically charges an hourly rate for that person's time that they spend, and nobody oversees it but the judge, so they can be spending 8 hours a day, 7 days a week at $200, $250 an hour, and that adds up very quickly.
Yes. Well, listen, that's what I need to share with this board. I need them to understand this, and now I thank you, and that helps a lot.
That could run into hundreds of thousands of dollars in no time.
Oh, real fast, and their dues today are nothing compared to that. All right, thank you.
Yes. All right then. Thanks for listening.
Yep. Okay. Yeah. You bet. Bye-bye.
We still have time. If you have a phone call, it's a question you'd like to ask Robert, uh, phone number here is 888 565 1470. I thought we have some great questions here. Here's a person who is a director on the board. I've never heard it put that way before, a director on the board.
We're all
Anyway, it says
directors.
the VP moved up to president, but he then moved out of the community. Can he still stay on the board even though he's not a unit owner anymore?
All right, so we're going to assume that moving out of the community means he sold his unit, because
Yes.
you can move without selling. The answer to that question is dependent upon what the documents provide for. Under current Florida statutes, which is specifically indicated in the not-for-profit corporate statute in Chapter 617, the qualifications to serve on the board only require membership or ownership in the community if your articles of incorporation require it. The statute says articles or bylaws, but it really needs to be in the articles, because if it's not, and it's only in the bylaws, there's a conflict between the two documents, and then the articles would prevail. So even though the statute offers both options, it really needs to be in the articles of incorporation. If your documents in your articles are silent as to the qualification to serve on the board as being an owner, then it's not required, and this individual could continue to stay on the board. Other individuals who aren't owners could also serve. So you need to check your articles of incorporation to see if that's a requirement in your community.
Okay. This is from Claire in Aventura. She wanted to know they're streaming their meetings, their board meetings. She wanted to know if it's okay that they record the meetings, or is that something
Off
that
of
has
the
to be in the
stream,
document?
I'm assuming off of the stream. Uh,
Yes.
Well, the statutes for both HOAs and condominiums and cooperatives as well provides that owners have the right to record meetings both audially and visually, so they can record a streaming meeting. The statutes allow associations to adopt certain rules about how recordings are being done, but that's more contemplative of the live meeting, so it's not disruptive. So where you put your equipment and things of that nature, or having to advance notify the board that you're doing that. So you have to check your procedures to see if you have any of that in place. It's very difficult to police, as it were, a streaming meeting and keeping people from recording that. So as this is a relatively new phenomenon, there hasn't been any court decisions addressing that specific topic. So it's kind of like open season for that.
Okay. Catherine in Deerfield. She lives in an HOA. They've changed managements. The new management company tells us they won't release the data unless they are paid $2,000. Can they do that?
I'm going to take that to mean that the old management company is telling the new management company that they can't have their information unless an old bill is paid.
Okay.
And no, they cannot do that. There is a specific provision in the administrative code that governs licensed property managers that considers that to be gross negligence and a very important risk on the license of the manager, that they're not allowed to tie association records to a contract that they may have that they think has been breached. So they can't hold your records hostage legally, They have to turn them over to you within 20 business days of a written receipt, or face the possibility of administrative action against their license.
Okay.
So that individual might want to get with their attorney to get a little tougher with the old management company.
Okay. Sid in Boca lives in a 55 and over HOA, and he said he's got a dangerous tree. I don't know what that means. He did say the roots are coming up, and he says he wants to know if he is responsible for the tree, like the association told him.
Well, I'm going to first say that I'm assuming the tree's at least 55 years old. Otherwise,
Probably.
that could be a problem right there.
Yes.
Maybe that's why it's dangerous. It's not the right age. But seriously, your governing documents in the homeowner association setting spell out who's responsible on the issue of the trees. And a lot's going to depend on precisely the location of the tree. If the tree is located within the lot, the private property of the owner, in all likelihood, that's going to fall to the owner, but sometimes landscaping goes to the association and tree maintenance and oversight falls to the association. So the fact that he says the association's telling him it's his responsibility could mean that documents do confirm that, but if he's unsure, he should check in his documents, declaration of covenants, to identify that issue. He may need to seek legal assistance to confirm that, but it's going to be a document-driven issue.
You know, I haven't asked you this in a long time. We've got a few minutes. So I'm going to ask you, why should my association hire your firm?
Well, there's many law firms out there that do what we do, but there are not that many that have been doing it as long or have the same kind of track record and base of knowledgeability. We have among our attorneys a large percentage of the community association attorneys who are board certified by the Florida Bar as condominium and planned unit development specialists. I'm one of them, and we believe that we're among the highest percentage-wise in the state that have that. So we have the expertise by virtue, and it's recognized by the Florida Bar. There's only around 200 in the state, and I think last count we were 8 or 9. So that's a large number and an important feature. We have the knowledge and the expertise. We can call ourselves experts in the field because of that. Otherwise, an attorney's not allowed to do that. We provide cost-efficient, fast, handleable service to our clients. If they're in need of a written opinion, we provide it quickly and in a format that's readily understandable to the layperson. We're always available to take calls. We're very responsive. And services is the industry we're in. Service is what we provide. Many of our clients would provide testimonials to that effect. I hear I'm being played off, so kbrlegal.com, 800-974-0680. I'm Robert Kaye. Thank you all for listening and asking your questions.
We'll be back next month.
We'll do this again.
Okay, have a good week, Robert. So on.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers.